Hello everyone and welcome to the second of our video tutorials on involuntary manslaughter. Today we're going to be looking at gross negligence manslaughter. The offence of gross negligence manslaughter, or GNM, is committed where the death is as a result of a grossly negligent, although otherwise lawful, act or omission on the part of the defendant. And that's one way that gross negligence manslaughter is different from unlawful act manslaughter, which we looked at in our last video, because UAM requires an unlawful act, whereas here for GNM, it might be an act or it might be an omission which has led to death. I'd like to start by reminding you of the different homicide offences so that we can see where GNM fits into the big picture. Firstly, we've got murder, where the actus reus is the unlawful killing of a reasonable person in being under the Queen's peace. Mens rea is malice aforethought, express or implied. We've already studied voluntary manslaughter, which is where the defendant has got the actus reus of murder because they've unlawfully killed a person, and they also have the mens rea for murder because they intended to kill or cause GBH to that person, but they had a partial defence of diminished responsibility, which was that they had a mental abnormality, or they had loss of control where they meant to kill but it was out of anger or out of fear, and both of those defences reduce what would otherwise be murder to voluntary manslaughter. Involuntary manslaughter is where we've got the actus reus of murder because a person has been unlawfully killed. However, there is no mens rea for murder. Our defendant didn't intend to kill or cause GBH. In our last video tutorial, we looked at UAM, unlawful act manslaughter, and this is also known as constructive manslaughter, where there's a small unlawful act, might be something like texting while driving, which has resulted in death. What we're going to look at today is gross negligence manslaughter. We're going to see that this is where the defendant owed the victim a duty of care, they breached it causing death, and that breach was classed as being bad enough to be criminal. It was grossly negligent. Gross negligence manslaughter is a common law offence, so it's not defined in an Act of Parliament. Instead, we've got to have a look at the cases. Before we look at some cases on this, I'd like to have a look at some of the sorts of situations that would be covered by gross negligence manslaughter so that you've got an idea of what this offence is all about. The circumstances in which you can get GNM are infinitely variable, but I've got some examples that are fairly recent here on this slide. Deaths following medical treatment or care which has been negligent are sort of typical gross negligence manslaughter cases. If I just switch you back for a second actually to the first slide, this is a fake image, but it's showing that a surgeon has left an instrument inside a patient's body. That would lead to death, and in that situation, that would be a classic GNM case because the duty has been breached, resulting in death, and obviously it's grossly negligent to have left those scissors there. Another medical negligence case involved this little girl here, Maisha Najib, where doctors negligently injected glue into her brain instead of dye. Now, I must stress, Maisha did not die, she was just paralysed. And this led to a huge payout by the NHS of 24 million. But the reason I'm putting it here is, had that had led to a death, that would have been an almost classic case of GNM because the very grossly negligent actions of the doctors would have led to a death. This image here was about a little girl who'd been on a bouncy castle, and the bouncy castle was not tied to the earth, and it was a windy day, and the bouncy castle blew away, tragically killing the little girl. We convicted these two who owned the bouncy castle of gross negligence manslaughter because by not tying it down, they had breached their duty to the little girl, resulting in her death. We've then got this case here involving a little toddler called Alfie Lamb, and his dad was convicted of gross negligence manslaughter when he crushed the little boy in his car seat by putting his chair back too far so that Alfie couldn't breathe. Another example here was a lady worked on a farm and her employer didn't give her the correct safety equipment, and so her ponytail got caught in some equipment and pulled her tragically into some machinery which killed her. And again, the farm owner was convicted of gross negligence manslaughter there. The really good example to use on gross negligence manslaughter is the Hillsborough case. Incredibly famous case, really tragic situation in which 96 Liverpool supporters tragically lost their lives as a result of a crush, which was mismanaged by the police. We don't have time to go into all the details of Hillsborough here, but it is a case that you should familiarise yourself with because it's really, really important in terms of legal history. The reason it's relevant here to GNM is David Duckinfield, this gentleman here, was prosecuted for the gross negligence manslaughter of 95 Liverpool supporters that died. The reason it was 95 and not 96, if you remember, is that Tony Bland, we've looked at his case when we've looked at murder and withdrawing life support. Tony Bland actually was injured and died sometime after the Hillsborough disaster. And at that time, we had the year and a day rule, so Duckinfield couldn't be prosecuted for his death. So Duckinfield in 2019 was prosecuted for 95 deaths, but the jury cleared him of this charge. That's something I disagree with massively, but that's a topic for another time. But it is just a nice illustration of the sort of situation that can lead to GNM. His failures, his acts and omissions, I believe, did lead to the 96 deaths at Hillsborough. Another example here would be the Grenfell disaster, and the police investigation into Grenfell has identified a number of suspects for corporate manslaughter and gross negligence manslaughter. But we're having to wait till at least 2021 for any charging decisions to decide whether we can prosecute anyone for this disaster because the inquiry is still ongoing. And another example fairly recent that's illustrated here, you might remember this one, really tragic case where 39 immigrants were found dead in the back of a refrigerated lorry. So these are all examples of GNM cases. Negligence is usually covered under civil law, but what we're looking at here with these examples is that some negligent behaviour which has led to death is so severe it should be punished with criminal law. And I'm sure you'll all agree that this sort of situation where you're putting people in the back of a fridge, that negligence is so bad it deserves punishment. What we've seen with these examples also is that a lot of them are caused through an omission, a failure to act. And that's an easy way to distinguish between UAM and GNM in a scenario in the exam, because we know that for UAM you need an act, but with GNM you can have an omission. So let's have a look at the requirements for proving GNM then. They come from the case of adamako, and this involves an anaesthetist who failed to notice that oxygen tubes had been disconnected from his patient. Even though alarms and things were going off, it did seem that perhaps he was asleep at the time. Medical evidence showed that a competent anaesthetist would have noticed the disconnection within 15 seconds, and his failures were, quote, abysmal. So he was guilty of gross negligence manslaughter. But what's important for us is it set out the three requirements. Our defendant must owe a duty of care, this was breached causing death, and the negligence was gross. I've put those requirements from adamako separately on this slide so that we can have a look at them individually. So as always, we're going to start off with requirement 1, that our defendant must owe the victim a duty of care. And for this, we start off by looking at Donoghue and Stevenson. Now, this is a negligence case from civil law, but we also use it when looking at criminal law, gross negligence manslaughter. So Lord Atkins set out the neighbour principle for determining whether there was a duty of care. And he famously said, You must take reasonable care to avoid acts and omissions which you can reasonably foresee are likely to injure your neighbour. Who then in law is my neighbour? The answer appears to be those persons so closely and directly affected by my acts and omissions that I ought reasonably to hold them in contemplation when directing my mind to the acts or omissions in question. So in a nutshell, he's saying that you've got to be neighbours. There's got to be closeness with foreseeability of harm. On this slide here, I've got some examples of when a duty has arisen for gross negligence manslaughter. So in Singh, a landlord owed a duty to his tenants to maintain a gas fire. In Lichfield, the master of a sailing ship owed a duty to the crew when he sailed knowing the engines would fail. Willoughby, really useful one for you to use in the exams. This case tells us there'll almost always be a duty of care between a doctor and a patient. But basically, you just have to be sure that there was a close relationship between the defendant and the victim, and that's usually easy to prove. If we have a look here at the case of Wacker, another tragic case with echoes of the one I mentioned before from 2019. In this case, 60 illegal immigrants died in the back of the defendant's lorry because he closed the air vent so they wouldn't be discovered. And the Court of Appeal said in this case, as long as a duty of care is established, it's irrelevant that the victims were party to an illegal act. So what our defendant was trying to say here was, well, he shouldn't be responsible. He shouldn't owe them a duty of care because they were acting illegally. They shouldn't have been sneaking around in his lorry anyway. But that's irrelevant. You can still owe them a duty of care, even if they're doing something that's illegal. See, using Lord Atkin's neighbour principle, that it is reasonably foreseeable that harm would occur if the driver of the lorry closed the vent. So it's reasonable for him to owe his passengers a duty of care. Another really interesting case here is Evans. Now, we looked at this case when we were looking at UAM because it's one of the drugs cases. And if you recall, our defendant supplied her half-sister, 16-year-old Carly, with heroin. Carly self-injected, and then the defendant failed an omission to call an ambulance. And our defendant was found guilty of GNM. Now, if you remember, the defendant couldn't be guilty of UAM because Carly self-injected. And if the victim self-injects, that will break the chain of causation, so it can't be UAM. But what we were saying here was the failure to call an ambulance when the defendant realised she was in trouble meant she could be liable in GNM. So if our defendant creates a dangerous situation, which has become life-threatening, there's a duty to act to save life. And I've just put a reminder there of Kennedy, which we looked at with UAM. So a drug dealer is not guilty of UAM if the victim self-injects, but they can be guilty of GNM if they fail to counteract this dangerous situation by calling an ambulance. So that's where UAM and GNM might overlap for you in a scenario. Requirement 2 for GNM is that the breach of duty must cause death, and we use the normal rules of causation here. Third requirement for GNM is that the negligence must be gross. Remember, negligence is usually civil, so for it to be a criminal offence, we must be sure it is gross. And the test comes from Bateman, and in Bateman they said it will be gross if it goes beyond a matter of mere compensation. So money wouldn't be enough. It showed disregard for life, and it does deserve punishment. So there's some key elements there. Compensation isn't enough, disregard for life deserves punishment. Confusingly, there is just one case on reckless manslaughter, but actually it would have satisfied all the elements of GNM. So LIDAR is the only known reckless manslaughter conviction where the probability of serious harm or death was present and the risk was assessed and taken by the defendant. Be aware of this, but it's not going to be massively important to us. The other thing to be aware of here at the end is that there is a Corporate Manslaughter and Corporate Homicide Act from 2007, and companies can be liable for this.